Good morning. A warm welcome to ILA event on what the clients want. I'll request Mr. Navneet Chugh, who is the president of ILA, to share a brief about what we do, what's our mission, and please start off the event, sir.
Sure. Thank you, Madhura. Thank you for doing such a great job with ILA. Good morning, everyone. Thank you for sharing your Saturday morning with us. I know you have lots of things to do, so we appreciate you giving us a bit of your time. By the end of the meeting, you will be happy you joined because it's going to be an awesome webinar. We started Indian Lawyers Association in India about 3 years ago, January 2018. It's an industry body. The doctors have a lot of industry bodies, so do the dentists, so do the chartered accountants and the engineers and CII and FICCI and ASSOCHAM and NASSCOM, but no vibrant Indian Lawyers Association. So we started one. We got political freedom in 1947 and economic freedom in 1991. The next big thing in India must come from law, from lawyers. Enough already. We put up with a lot of not good stuff for 74 years, and it's the lawyers' chance to take turn and contribute to India. We have a lot of work to do. We need to fix the legal profession. There's 1.4 million of us in India, and Bar Council says 700,000 of them have fake law degrees. That's not good for our image. We need to upgrade the image. When parents are looking for spouses for their kids, it's always doctor or engineer or dentist or whatever. Lawyers need to be first. We need to make more money than are paid now, except for the 6 panelists we have today. The rest of the lawyers deserve to get paid more than they are getting paid. We need to help India. We cannot become a first world nation with a third world justice system. The World Judicial Council ranks us 100 in ranking out of the 192 countries in the planet. We need to help the people of India. Dying without justice is not justice. Delayed justice is not justice. 36 million pending cases. It's shameful. Somebody wrote that it'll take 466 years to clear the backlog. 10 million alleged criminals lying in prison waiting for a trial. They have already spent more time, some of them, than they would have had they pled guilty on day one. We need to fix every single angle of law in India. At least start with a simple law that says every case that emanated out of before 1947 is finished. The oldest case in India is from 1878, a land dispute in Varanasi. We need to help the economy of India. Presidents of companies tell us, I wish my contracts would be enforced. We need to fix IP, we need to fix taxation, we need to fix land disputes. Billions of dollars of land is lying in waste because of legal disputes. And finally, it's such a pleasure to have 6 general counsels in the panel. And I'm going to exceed my limits of decency, and don't know when I'll get 6 general counsels to listen to me for 30 seconds before they cut me off. But general counsels, I want to tell you that you are humongously powerful people, and you should use and abuse that power. Join your local ILA. If there isn't one in your city, please start one. Please become president, get involved. If you don't have time, get one of your juniors from your office involved as your alter ego. At least once a year, not more than that. Once a year, host a ILA event at your office. Get some tea and samosas, get some young lawyers, mentor them. And then finally, use your power as general counsel. Insist that cases must settle today, must settle this week, must settle this month. Otherwise, I'm going to fire you. Don't do this arbitration and mediation in Singapore. No first world nation does arbitration of their country's disputes in another country. That's shameful. And don't hire arbitrators and mediators that say, okay, we're going to do first hearing today and the next hearing 6 months from now. Fire them. That's unheard of. Don't put up with it. You get days consecutive, or you will go to another mediator. If not, you'll call up the opposing counsel on the phone and settle the case. and insist on pleadings and not oral arguments. You don't need senior counsel to make oral arguments. Hire a junior lawyer who can write and insist on pleadings. And please put pressure on judges, politicians, presidents of your companies, junior lawyers, law schools. Enough already. Let's fix everything that's wrong with the legal system of India so that we can become a first world nation. Thank you so much for participating today. Thank you.
Thank you, sir. Before I hand it over to
Madhura, we
Veena,
can't hear you very
the
well.
moderator for the session, just a quick couple of house and questions in the chat box. Uh, can you hear me now? Am I audible?
It's flaky, but I'm not sure if it is just for me, but please go ahead. Sorry.
Okay. So to the participants, please put your questions
Veena,
in
it's for
the
everyone.
chat
Even I can't hear
box
her.
and request you for the betterment of the connectivity. Am I audible now?
Actually, Madhura, let me take over. Thank you so much for organizing this event. I'll just go over the housekeeping rules as well. If you have anything to add, Madhura, just type it into the chat box, and I'm sure our attendees will pick it up. So my name is Veena, and I'm an employment lawyer with AZB and Partners. Like a lot of you will be aware, AZB is a full-service law firm with expansive practices in M&AP, real estate tax, all of it, full service. I have only worked in law firms and have never been an in-house counsel. So I'm going to keep my introduction really short, my questions really crisp, so I can squeeze every thought and idea out of the 6 wonderful panelists that I have here with me today, to understand what their expectations are from law firms, to figure out how we can all collaborate and get work done better. And like the topic itself says it all, what do clients want? This is going to be with the next 1.5 hours. It's going to idea is to have a comfortable, free-flowing conversation, settle down with your beverage of choice, and I'm sure this is going to be really interesting. And use this opportunity to ask questions. Do key in your questions in the chat box. We will do our best to pick it up and have it addressed as part of this conversation over the next 1 hour. I am super grateful to our panelists who agreed to be part of this, and to agree to something where you have to be really candid and upfront about your thoughts and experiences is commendable, and I'm very, very happy about it. So I'm going to request our panelists to introduce themselves, and when you introduce yourself, please talk to us about your growth and your journey as a lawyer. Just spend about 2 minutes telling us why you became a lawyer, how have you grown, and how you continue to grow. So let's start with Roshan.
Hi, thanks, Veena. Thank you so much, and good morning, everyone. My name is Roshan. I'm leading or heading the legal compliance, integrity and compliance, and secretarial for Edeco Group in India. And my journey of a lawyer, right? I didn't know I would never become a lawyer, honestly, but I did. And when I did, I thought it was a great thing to become a lawyer. And through the course of my journey, what I probably did was I did bits and pieces of a lot of things, including litigation right in the beginning in the high courts of Bangalore and the district courts here in Bangalore, India. And I've also touched upon a bit of consultancy. I was a consultant for one of the big fours, rather. And then, I thought my passion always rests me with, by knowing either sides of the coin, I could support organizations. So then, I turned into the in-house side of it. I think there's a lot of learning. I wouldn't say which one is the best of them, but I think everything associated with law is really nice. and great. So I'm really glad that I became a lawyer when I speak today. Thank you.
Thank you, Roshan. Priya, would you like to go next?
Sure. Thank you, everyone. I'm working for BNY Mellon, Pune. I head the employment legal department there, and I have been working in the financial industry for over 20 years now, and predominantly been an in-house counsel. So I started off work at an era when computers were rare. It just used to be one box computer sitting in the corner of the office, and we had to literally book our time to be able to use it. And the programs used to be like Fox Pro and other things that people have probably of this generation are not even aware of. So starting with that pen and paper, I'm still very fond of pen and paper, but over years, I think as a journey, as an in-house counsel, I think what's been pertinent in terms of my efforts have always been to try, and Mr. Chuk spoke about timeliness, and that resonates so well with me, and I'm sure many others, that the time with which we provide or turn around quality advice, and breaking that myth that, if things go to legal, it just gets delayed by months. So I have consciously, with full disclosure, been attempting to be a counsel, who breaks that myth. And I enjoy, like Roshan said, I really enjoy my profession. I don't know why I really got into the profession. I can't recollect perhaps, but I don't regret it one bit. And I've seen the ups and downs, and I've seen courtroom dramas, and I have been, involved in litigations myself, been a party as a company official. And I recollect somebody recently telling me that, then you must be really very fearless. So I take it with a pinch of salt and with a lot of pride that perhaps this is the time to use our power to start giving back. And I really resonated that as well with Mr. Chuk. Thank you.
Thank you. Thanks so much, Priya. Navroz?
Hi, Veena. Good morning, everybody. Unlike you, Veena, I've been a in-house counsel through and through, so I'm absolutely on the opposite side of the spectrum. So, however, I have a very interesting story as to how I started off. After graduating from law and after getting that degree in hand, that's when I questioned myself, why did I do law? So there was a completely, it was completely, I reached that crossroad after 5 years rather than starting it off at the very beginning. But it kind of gave me a good 6 months to think about what is it that really interests me in law. And of course, my love of technology and IP got me focused into working with some of the top technology companies in the industry, and that kind of paved the path for me in terms of helping me be what I am today. So I'm currently the global head of Scient, and we are headquartered out of Hyderabad. It's a engineering outsources service provider. And I'm just, I'm very happy that, I'm getting to speak with so many esteemed panelists, and of course, Mr. Chug and you, Veena. Look forward to this.
Thank you. Yes, I am certainly looking forward to this. Harshita, would you like to go next?
Good morning, everyone. This is Harshita Tamaya, and I'm the General Counsel of Xiaomi. Firstly, thank you for your words of wisdom, Mr. Chuk. I think I totally agree with you that we need to reflect and see and try and fix the problems with our profession. So in my case, what started as a journey of escape from mathematics actually led me to become a lawyer. I was so fed up of mathematics in whatever little time that I've studied. So, I thought law was the best profession. So yeah, that way it was pretty, well thought out for me, because this was pretty much the only option. After that, so I have been a corporate lawyer all my life. Having spent a decade at a law firm, I realized that the partnership roles really don't interest me as much as the business side of things. That's when I glided on to an in-house role, and I started my journey with Xiaomi. I've been with Xiaomi for the last 6 years. And I don't regret one bit. I'm not sure. I know it's too early to say never, but I don't know if I'd ever want to go back to a law firm because the in-house role is very exciting because you get to sort of relate to how things are done from scratch, and all the legal advice that we would sit and turn out as law firms. It all sort of is contextualized in the business, and how business people think and how they sort of turn out solutions is something that's pretty exciting. And yeah, it's been 6 years. It's been a super accelerating experience for me. So that's my short journey.
Thank you, Arshita. And you don't have to do time slip. So
yes, another incentive, totally.
So, Shyam?
Yeah, am I audible, Veena?
Yes.
Yeah, good morning, everyone. Extremely happy to be here, and thanks for this opportunity to be on this esteemed panel. My name is Vijay Shyam Acharya. You can call me Shyam for short. So my journey is slightly different, and as Navroz said, I've been a complete in-house counsel, never had an opportunity to be with the law firms. But my journey started off as a typical South Indian who was encouraged to do CA, CS, LLB, ICW, whatever. And then, started off as a finance guy, then became a finance guy with secretarial responsibilities, then a secretarial guy with legal responsibilities, then a predominantly a lawyer with a fair bit of secretarial responsibilities, which is what I am today. So over a period of time, I've been working with various industry houses in India and abroad. So I was with the Aditya Birla Group, I was with the Landmark Group, I was with Automobile, and last 5 years, I'm the global head of legal and company secretary of Quest Global, which is into engineering and software services. So in terms of what I've done, I've been predominantly an M&A counsel, and the typical role of a GC in the day-to-day stuff, litigations, contracts, international contracts, customer acquisitions, so on, and litigations, especially some of these high-profile, high-ego kind of litigations, so on and so forth. So that's my journey of around 20 years. And as some of the panelists expressed, I think there's so much in this field to do, so much more to do, and especially when you listen to the introductory speech which Navneet gave, it gives us a feeling that we have only scratched the surface and there's so much to do, so much to go. Thanks, Navneet, for that extremely motivating and inspiring introduction. I must say you think very, very differently. Yeah, that's about me. Thanks, Veena.
Thank you. Thanks, Shyam. Sonal, tell us a little bit about yourself.
Good morning, all. Thank you, Veena and Navneet, for inviting me on this panel. It's been an interesting journey. I am a first-generation lawyer, so I have no idea, what I was going to study. But I have no regrets at all. I started my journey nearly 20 years ago, and I've been with the TMT space. I've worked with a law firm, briefly, and I really respect a lawyer's life in a law firm. I think it's equally challenging for in-house counsels as well, because there's a lot happening. While lawyers in law firm focus on solutions, in-house counsels are thinking of problems already. I think that's the difference, right? I think this profession is quite an important profession because, as Navneet said, we can really make an impact. And I think as we get older, or as we get more experience, we can really contribute, in many ways back to the society, back to a fraternity in multiple ways, in terms of, providing thought leadership, in terms of improvising the processes, cutting down the disputes/litigation time frame. Navneet, I totally echo what you've said. You can just pick up the phone and talk to your opponent counsel and make things work, because ultimately, you can fight forever. But it's only up to you how much time you want to expend, time and money you want to expend on that particular matter, right? So it's a very palpable profession in my view, and all of us, even if you give back a little bit of your time to make an impact, you can really make a difference. So I'm really happy being in this profession. Thank you.
Thank you very much, Sonal. Okay, let's get started. Have we covered all the panelists? Yes, yeah. Okay. When it comes to any engagement in any service, there is always something called the cost, quality, time triangle. So it's sometimes about where you can trade off, where you can't trade off. But I'd like to hear from each of you on what is it that you look for in terms of quality. We'll come to cost and time later, but quality when it comes to law firms. And how has that evolved? Because some of you have been in the practice for a while, and I think with information availability, a lot of expectations on quality would have also evolved. Who wants to go first? We'll start with Shyam, I guess.
Okay, so Veena, I fully agree with you in terms of the triangle, and I think that's the same for any service. I know because when we work on client acquisitions, customer acquisitions from a software services perspective, that's the topic which is always discussed. So I think it's more universal that you can have 2 out of 3, but not all the 3 of them at the same time. And that's a fair expectation of any service provider. Having said that, I think, I'll address each of these 3 separately. When it comes to, quality, I must appreciate that today most law firms are quite evolved, and they have standardized quality parameters due to which the quality of service generally tends to be quite satisfactory and quite high, except maybe very, very exceptional cases. Generally speaking, when we go to any good law firm, we have the assurance that the right quality is coming in. And I've seen this of late more in India than in foreign law firms. I mean, you may say I'm going against the current, but I now see Indian law firms delivering wonderful quality. I'm not just talking about the level of quality. It's like the assurance that, you go to this law firm, you get this quality. So generally no complaints there, but I'll just touch upon 4 or 5 aspects as far as quality is concerned. First thing is that, whatever be the arrangement, in terms of fee and timelines and so on, once something is agreed on quality, I think it should be clear that there's no compromise on the agreed parameters. I think that's very important. It shouldn't be a situation where a law firm has to come back and say that, look, the time and cost parameters change, so I had to change the level of quality as well. That is something simply not acceptable. Second thing is about conflict of interest, and I'm putting it in quality for want of a better bucket to put it into. Many times we do see, though law firms have very strict rules in terms of conflict, and many times, rather most of the times, they are very transparent, very much on board, they clearly disclose and so on. I've also had a mixed bag of situations where I felt, the whole understanding of conflict could have been slightly better. Because just to give you an example, once I had a real estate transaction where I am on the buy side, and I had engaged a law firm for due diligence. And after due diligence, when we actually met face to face, and obviously this is much before COVID, around 10 years ago. So when we met for the negotiations on the documentation and path forward on the deal, the lawyers on the other side exchanged cards, and they were the law firm I had engaged to do due diligence. And they were sitting there on the other side. And I just gave them a blank look, like they understood what I was doing. So they said, no, these are two different, due diligence and deal negotiation are two different, buckets in our law firm. There's a Chinese wall in between them. Well, I appreciate that, but you could have told it to me. All I expect is a disclosure. I'm not telling you don't do it, but at least a disclosure is the least, I could expect. So I could give more examples like this, but I think this is very important, especially in some litigations. I've had situations where I have litigated with a much bigger player, and the law firm felt it politically incorrect to work against that particular client. It could be a big bank or something like that. And law firm didn't correctly disclose. So there could be more examples, but that is one aspect of quality. The next aspect of quality is that while you could get into details around how much of detailing to do and how much of high level to give, the client, what he expects from a law firm are predominantly two things. One is, what is the rest of the industry doing, and am I on par? This kind of constant benchmarking process, which a law firm is better able to give because they work with multiple clients and they know the industry probably better than us. So that kind of a benchmarking and giving advice on, hey, look, this is what is going around in the industry. That is one thing I would expect. And in terms of other aspects around, quality, it is more of an assessment of business risk. I mean, each corporate has its own assessment of, business risk. And we would expect the law firm to understand what is our assessment of business risk and give us a return on investment based on what risk we perceive. And when I say return on investment, I'm talking not of the monetary side of things. I mean, it's not an exercise to reduce the fee or something, but try to address us in a way that takes care of our assessment of risk. So that's around quality, and maybe whenever my turn comes next, I could speak about the cost side of it as well.
Sure. Thank you so much, Shyam. So on quality itself, I'm fairly sure the other panelists will also have like similar thoughts on this. If there's anything specific that you all would like to add about it, please go ahead. Harshita.
I think quality, as far as at least the tech companies are concerned, is always, at least I'm talking about the new age companies, etc., is giving something which is more than stating the obvious, right? And that's something that I really value. Like Mr. Shyam correctly said, benchmarking or the industry insights becomes really helpful, other than just telling me what the law is, because knowledge is out there. You can open books, you can interpret law, because legal departments have smart lawyers. Legal departments, some of them would have actually worked so well in that particular area, they could actually acquire expertise. So we know the law. What we would really like is some addition of value that is much more than just what is there, right? So that's something that legal departments would expect. The second thing is not much is spoken about this, but I think we should sort of give some emphasis on the form also, form of your deliverable, right? In a lot of cases, what happens is you turn around a document or you turn around an opinion, etc. It is lengthy. It becomes very convoluted and difficult to read through, grasp what you're trying to say, right? So if an emphasis is duly given on the form, on how easy you make for your clients to understand things, because at the end of the day, the clients of the legal departments are the business departments for non-technical people, right? If we have to communicate that, and if you're aiding us in communicating that better to our clients, it goes a long way in sort of creation of the value and really adding value to the quality that you're providing. So that's something that I thought I'd highlight.
Thank you, Harshita. I think this is also something that a lot of us are trained in from day one saying form is as important as substance. You can't, right? Whether it is sending a holder or formatting your email or your document a particular way, it is, I think the word is out there on form is not less than substance. Both are equally important in terms of readability, in terms of context, in terms of communication. Roshan, you wanted to share your thoughts.
No, I think Harshita kind of touched upon what I wanted to say, but still, see, I think quality is paramount, right? I mean, because we are as in-house counsel, what is that we are seeking from law firms? We are seeking advice from law firms, opinions from law firms. Now, it's a make or break situation for the organization, right? It could be a very sensitive issue. It could be something. Now, if quality is not there, probably in terms of the quality of opinion, it can break the organization completely, derail its business, so on and so forth, right? And when I talk about the opinion that has been given, or the work product, the deliverable, if it does not meet the requirement, it's completely of no use, right? And it just not that, it needs to be tested. So let's say if there is a interpretational question, that's when we try and reach out to firms in the first instance, right? And if it does not stand the test, a true test, when it has been tested at a later point of time, there's no point in seeking such kind of an. So I think the way I look at it, probably, cost may come secondary, but quality should be top notch.
Yeah, and Veena, I would like to add to what Harshita said. When we reach out to law firms, we already know the answer. We just want a ratification, just to be, because law firms represent the buy side, the sell side, larger fraternity, clients across various industries, right? So if you get an opinion which has a disclaimer of 3 pages, you don't feel happy about it, right? So that's the first point. And secondly, I think law firms know what they are working on, or their assignment. So I wouldn't question their quality related, I won't have any doubts vis-a-vis their qualities. It's just that they need to understand that it's not just, they cannot just think of the question that's been asked. I think they need to go beyond and understand what are the other aspects which the client would want to look at, right? I think that's where they add value. That is one. Secondly, I think which is extremely important is how often do you communicate with your client? Are you communicating throughout, or do you only communicate with your client when they reach out to you? Because if you're doing the latter, then there's a problem, because there's so much happening in your industry, right? You should be attuned like an in-house counsel vis-a-vis the problems that the in-house counsels would be facing at some point in time, because the laws are not clear, the laws are not abreast with the technological developments, or a lot of things like that. So I think it's extremely important to be an extended in-house team. If you're working with a client for many years, that's another thing which I guess all the in-house counsels expect from the law firms.
That was valuable. I'm going to pick up on that point of keeping in touch and being in tune with the client, and not really be a response provider at the end of this. But let's just hear Navroza. Do you have any thoughts on quality, Navroza?
Yes, and in fact, Sonal touched upon a very, very important aspect, that how the external counsel needs to be attuned to the way an in-house counsel thinks and is expecting them to give answers. So generally, when we look at things, we look at them, and that's because our internal stakeholders require that, is looking at things in black or white. They do not want the gray in between. So they do not expect us to go back to them saying that, here's an option. You can, this is what you can do. But by the way, there is another option also that you can think about, and, try and see which one weighs best for you. And that's when, your stakeholder is bound to come back and tell you is that's your job. I mean, that's what you're supposed to do as an in-house counsel. And that's exactly what we look at from an external counsel. Coming to the quality aspect, and you touched upon the triangle of quality, cost, and time. And to Roshan's point and Harshita's point, I think the quality aspect is something that cannot be compromised by in-house counsel at all. And in that triangle, the counsel is always in the middle of that triangle, trying to attain quality, but does not know how best to manage the cost and the time. So I would say that time is something which is still, as in-house counsel, we can manage, because there are some things that are absolutely time bound, but there are some things that we can always, in order to achieve the right quality, we can always compromise on the time part. But of course, then comes the question of cost. So the more the time you spend on external counsel in achieving that quality, the cost goes up. So it's a catch-22 situation for in-house counsel at any given point in time.
That is very. I think that is very candid of you to put it out there. That you are in the middle of the triangle, and you have a lot of decision making to be done in terms of cost and time, and quality has to stay a constant. So that is one part that is non-negotiable. Going back to Sonal's point on being not just a question answering service, but being a trusted advisor for the client, be in touch with the client. I've seen a lot of law firms over the years run newsletters, and this is internationally and in India. There are webinars, there are business development meetings, there are very targeted sessions and workshops that are held for clients. There's a whole lot that law firms, at least some law firms across the world, do for their clients. But there's always this little nagging thing, which is, when is it too much? Am I being too salesy? Am I spamming the inbox of my client with 100 updates on a daily basis? So what are your thoughts on that? And I would really like it if you're very candid about this, because I know there are days when it is probably too much in your inbox.
I can start with that, because, and I won't name the firm, but I know this firm for last, I think, nearly 18 years now. They were on the other side when it's an international law firm. They were on the other side when I was working on a very large transaction in the UK. One thing which they do, and of course I engage them off and on for international matters, is if there's any case law, or if there's any change in law, or some consultation process that has begun, they reach out to us and they ask us if you'd like to discuss or debate on any particular nuance which may impact the industry. I think that's where they make a difference. And I can tell you, not that they pitch for any work, because by default I end up going to, because they're way ahead of time. They are already thinking of the problem. They're thinking of what's affecting the industry, how they could make it easier for the industry or the clients, right? They also have a holistic perspective. So I think, of course, webinars, the newsletters, those conversations or those modes of communications are ongoing. But this is one thing which I think really makes a difference. I don't even have to, when I know if there's something happening in the privacy space in India, for example, if the law firm comes to me and says, hey, Sonal, you know what, this is going to impact your company or industry, that's a conversation I would love to have. Even before we actually wait for the law to get enacted, we're already having, focus on thought leadership, and they're truly collaborating with the in-house team. So that's my view.
So
thank you. Yeah,
thanks,
go ahead.
Sorry to interrupt. Yeah, so you spoke about this bombarding of emails. I think that's one common problem all of us face. I think it has a simple solution, and many a time I understand there are practical difficulties for law firms in implementing the simple solution. But the simple solution is that you understand obviously what the client is into, and you only send him, those updates, in a much crisper form, rather than, giving a complete set. For example, I get updates which has anything from forestry to metallurgy to boilers. I mean, I'm in a service industry now. In my current job, I'm okay if I'm not up to date on some law relating to boilers. So it becomes a standard thing, which is I think the whole idea is to be all encompassive, and in that urge for comprehensiveness, crispness is lost, and that is when the bombarding becomes. It's like more, okay, technology is doing its job, but there's no personal touch to that relationship. I think that's something law firms could.
I think, right. I think that's the differentiator that Sonal's talking about. She's not talking about a general email that goes to everyone. It's an email saying, hey, Sonal, this is what we've seen. Let us know if you want to chat about this more. I think that is very relevant. Any thoughts on this aspect in terms of either holistic advice on you've already told us about how you need business, how you're looking always for business friendly advice, on maybe some feedback for lawyers in terms of how we could keep this connect alive a lot more and not just respond when there is a question.
Veena, I just want to add a point here, basing on my personal experiences. So there is a law firm, there is a lawyer who I think I was never using when I was working in that particular company. And it so happened that, it was a viewpoint made by that lawyer at one of these seminars where, the lawyer made a very strong viewpoint, which was slightly different from the viewpoint that was being made by the panel or the speaker. And that piqued my interest. And then during the introduction, it turned out that this person was, part of a law firm. And then we thought, oh, why not, start working with this person, because he or she is coming with that kind of a refreshing idea. So, and to the point on materials, and I think the adage that too many cooks spoil the broth perhaps doesn't really work for this profession. The more the merrier is my mantra. The more you read, it's like, people buy different newspapers. They just don't stop with one edition. The news might be the same, but the way it's being presented, the way it is interpreted, now we do know that there is a lot of political aspects to it and things like that. So it is very interesting to know the way they interpret these things. So to me, it is like, why not? Why not know something about forestry? Maybe you never know. It is just something that you just put it in your brain and, put it aside, and you never know when that's going to be useful to you or not. But I do appreciate, bombarding is not something any client would prefer. But I think it's up to us to see what we want, what we don't want. And I really like the way the other panelists spoke about connect. And like I said, that's very important. Another lawyer that I know makes an effort to actually call and say, I want to pick your corporate brain, because that lawyer probably has never worked as an in-house counsel. So they are very curious and want to know, okay, what will you do? What will, how are you going to answer this question if somebody poses this to you? And I think to me, it's a great evolution of the, from the traditional way a law firm and a client used to work. And we're literally collaborating, we're literally partnering. And that's just great. The ability to actually pick the corporate brain or vice versa is great, actually.
Thank you. I'm just going to summarize what. Go ahead.
Sorry.
Go ahead.
I completely agree with what Priya just mentioned. More the merrier is what I believe in too, because it's not necessary that I need to be zeroed in on what is the organization or industry I'm working on. So newsletters and information is all welcome. I'm sure even in this group, you probably the audience here, you might see a lot of people from various aspects of life as well, or profession. The only thing probably, any conversation a law firm is making need to ensure that they're not really coming with a hook, right? Somewhere I feel some of the conversations are only sales pitch, right? and it's just a teaser that has been given to you stating that, hey, there is a new, let's say, the recent changes in the wage code, and then stop. It's not a collaboration. It's not understanding. It's not necessary that each and everything needs to be built in voice. So probably, it's okay to let loose certain aspects so that we grow things together, more collaborative.
Thank you, Roshan. But I'm just going to summarize my learnings on this, connect with clients, part of it to say information is welcome, but maybe I'll add to that and say keep it crisp. So we're not sending pages and pages of information. So even if it is not super relevant to the organization or the industry, it's a quick half-a-minute read and everyone can move on. And if there is interest, then the client will always come back to you with a question. And that, again, engage without having that hook. Everything is not really always a pitch. So yes, I do believe in building relationships, and that will translate to a client. So that is valuable. I think it's a good time to move to cost, and that's always been a tricky conversation. And there are multiple sides to this as well. So I think who wants to go first on this? Navroz?
Of course.
Sorry,
thank
Priyanka.
you.
Okay,
No,
okay,
no.
Navroz, go ahead.
Please, Navroz.
Sorry to speak over you, Priya. I think that's a wonderful topic to speak about, and I'd love to have this conversation with you on the other side of the table, Veena, as a as a law firm, from a law firm perspective.
This is why I'm moderating today. I'm not answering questions today.
So, well, you may not know, but probably all of us may have colluded to try and put you on the spot, but we will not do that. So we've whenever we've tried to analyze so I keep going back to the triangle that you mentioned, and keeping quality in mind. Of course, that is paramount importance. I think everybody is in agreement on that. Now, coming to the cost factor, and probably if you permit, I can share the analogy that we had discussed a couple of days ago.
Of course.
Yeah. So when we were approached by some firms for a particular piece of work, we had a firm that came to us and said that, listen, we'll give you the Rolls-Royce treatment. And with that, keeping that in mind, we understood that with the Rolls-Royce treatment will be the Rolls-Royce cost. So instead, I know that for the same transaction, because at the end of the day, the car is going to take me from point A to point B. The quality of the ride is what is of paramount importance. If the same quality of the ride with the same road conditions can be achieved with a Toyota, why do I need to go to a Rolls-Royce? So, and I can, of course, there might be the difference. The only slight difference might be that it may have a lot of additional peripherals that may come with the car. So similarly, if the Rolls-Royce breaks down in between, imagine the cost of repairing it. So as you go on, it is like, you are adding on, it's a scope creep. So the firm will always try and add on additional customizations to the work that they're doing, which will increase or inflate the cost. However, with a Toyota, I might just get a package of like 5 years of service. So that means that every time all I have to do is just pick up the phone, call my lawyers and say that, what, I have a question for you, can you answer this? They will answer it, and they may not bill me for it. So that's the parallel that I try and draw whenever I am evaluating a law firm, whenever I'm taking a law firm on board for a transaction. I'm keeping in mind the expertise or the subject matter expertise that they bring to the table. The other thing also that, the last point I'll make before passing it on to somebody else is many a times full service law firms, they may claim that they are full service law firms, but then they will outsource that work to a smaller firm, or they may outsource it to individual counsel, and then they mark up the price. They'll inflate their invoices, and then they'll send it to you for payments. So that is something that we have to be very careful about. So we make sure that we go to the right subject matter expert. And in fact, we encourage law firms to tell us that, okay, if you do not have that expertise, let us know, and you guide us to the right person. We will go to them directly. That's my 2 cents on cost.
That is a very important part, Navroz, the one on where there is a lack of expertise, and there will always be something that maybe a consultant or somebody outside the firm does better. So you could either front end it for the client or put them in touch with the client directly, but calling it, getting somebody else to do it and marking it up and passing it off as your work may not be the ideal approach. So, and keep, again, we go back to point number 1 here on quality and being trusted advisors for your clients. If the least we can do is be transparent about it.
Yeah, I think transparency is extremely important. And I think that's how you build the trust with your client, right? It's not about money always. It's about building the trust. And if you are transparent with your client would always be with you. So I think it's extremely important about, not billing those 2 extra hours, but being with the client in the journey, or, working with the client in finding the solution. So I think transparency and that trust building are key parameters for any relationship.
I just want to add a point, narrate a personal incident. So we were having some difficulties with one of the landlords from whom, we had taken a property on leave and license for one of the expats, and the expat had actually left the flat extremely dirty. He had clogged up the pipes and broken the bathtubs, or it had an in-house swimming pool. So the swimming pool was a mess, and the landlord actually refused to give us the security deposit back. And he said, look, this is what has happened. And I really appreciated that, this went on for a long time, and I was just in the copy, I was CC'd, and I was like, okay, I'm not going to enter into this arena unless and until I've been called out for. And the lawyer actually called me and said, you know what, Priya, this is kind of going beyond legal. So I am sure if somebody from your office speaks to this landlord, things will, even out. And that was just one phone call, and I got in touch with the HR head, and both of us, discussed, and I went and spoke to the landlord, and he said, I'm so happy to see somebody from the company to actually talk to me, because I didn't want to speak to the law firm. For them, they felt that it was very impersonal. Law firm was somebody they didn't recognize, and they were wary and scared of talking to a lawyer candidly. And he even offered to show me the flat and said that, you can have a look at the flat in Worli. It's in a total mess. He showed me some photographs, and it broke the ice so well. And I really appreciated the gesture, because the lawyer could have extended it, taken more money in because of the now billable hours, etc. But I think it was a mentality of wanting to get this resolved in the right way. And I think that counts a lot for us as clients. And these are the unique selling points that we perhaps will see in a lawyer saying, okay, what is it that you want to do? I happen to bump into the opposite lawyer. They are actually willing to settle. Would you really want to talk about it? So that opening that conversation makes a lot of difference in terms of the quality, and obviously it has an impact on the cost in that case.
Right, the solution-oriented approach is important, and you don't want to be that person who's always trying to get your clock ticking. It's about being a genuine advisor. But we're going back to cost. So in terms of billable models, in terms of charging models. There is a hourly rate, there is an estimate, then there's a fixed fee, now there's value-based billing. There are some firms who take the approach of billing based on satisfaction. So if you're happy with it, then you pay us more. If you're not, then you give us, we cap it at a particular amount. There's a lot of fluidity now, and the space is evolving. Traditionally, it used to always be the billable hour, and that is from a law firm perspective, I will tell you, it is a lot more comfortable. But I do understand that there will be some, there would be other forms of billing and charging that needs to be put in place. So, what is, if one of you could just talk us through your thoughts, your preferences, and what is it that you really don't like when it comes to billing policy, and what is it that you like?
Hi, Veena.
Yeah.
I'll go first on this. For me, as far as the cost is concerned, if the quality is that of value addition, I think it goes a long way in justifying the cost. So that's the premise on which I'd like to go. On the pricing models itself, I think hourly rates, like you said, it is good for law firms, but it is quite scary for legal departments. Scary because one, it's a pretty obvious thing that the legal departments are still viewed as costs, though that perception is gradually changing. These cost centers, and therefore there are budget limitations, etc. Hourly rates have the tendency to sometimes go really close to these budget restrictions that we might have, and it's a lot of uncertainty, right? You don't know how much is going to, at the end of this thing, you say, oh God, I expected this to actually cost a certain amount, but then it is gone a couple of multiples. So value based in terms of the fee estimate is something that always gives clarity, even though it is an hourly basis, hourly rates that you apply. If a client is told upfront that this is the scope that we have decided, we expect that it would consume so many hours, and therefore your billing will be in this range. So that is a communication that immediately gives the comfort that this person is really not trying to overbill. This person is trying to sort of keep within the cost. To basically, there you're ironing out the expectations, mismatch, right? So this is okay. This is the estimate that would work for me. Please go ahead. So at that time, a law firm partner need not actually worry about having that fear. Okay, I just lost you for a second. Having that fear that maybe if I sort of overbill, I will have to cut down on the time, etc., etc. So that's one fee estimate I'm a huge fan of, and I always insist that we have some visibility as to how much this is going to cost. And second is of course when you're actually writing up your scope, yeah, make sure that your scope is clear. Even though it is a small piece of work, a conversation around what it will include and what it will exclude will go a long way in sort of bridging that trust building exercise will actually strengthen it. And it's always wrong to make assumptions about assumptions that we write in the when it comes to writing the scope. So that's something that has to be borne in mind. So yeah, in short, I think it's the value-based billing that will really sort of pave a long way for the relationship building between the law firms and in-house legal departments. And that value addition should also be in terms of achieving the perceived goals or the value that the legal department would want to create for its business departments. So understanding the context, being crystal clear about the scope, and having certain really solid, reasonable assumptions is a pricing model that I think would be ideal.
Thank you, Harshita, for this. And I'm going to re-emphasize on the fact on the importance of a scope at the beginning of any assignment or any retainer project or anything. Just saying, I've seen a lot of times people being hesitant to say what is not included. And what that ends up being is that is simply creating a communication gap. So, and it's ultimately you interacting with a service recipient, and it's perfectly all right to say what the cost includes and what it does not, and then you can speak about it. If there is a negotiation, then talk about it and sort it out. But rather than assuming and having both parties assuming different things. Any other thoughts on this? This is on the estimate-based approach, which I'm a huge fan of as well. Anyone else would like have thoughts on the cost perspective? Shyam, I believe this is something that you wanted to talk about.
Yeah, thanks, Meena. So it's like this. I mean, Navneet spoke of GCs being extremely powerful, but unfortunately, we are not so powerful that we can ignore budgets. So Harshit also spoke of that. So that whole thing which Navroz also spoke about, being in the center of the triangle and trying to balance out that act as as you are the fulcrum there as an in-house counsel. So yeah, traditionally we had Arlie and we moved on, and we have a lot of alternate billing models now, and there are a lot of wonderful stories both from the law firm side and the client side on many of these alternate billing models, which are a win-win for both parties. But I still feel, these alternative billing models are not completely understood, both on the law firm side and on the client side. Just to talk of this capped fee kind of thing, so yes, you say it's a capped fee, but obviously it has to be based on certain assumptions. It cannot be unqualifiedly capped. And when those assumptions are made, there is a mistake which both the law firms and the in-house counsel do. Like I've had many times law firm counsel, kind of calling me in confidence and telling, hey, look, I'm working on this with some other client, just like Priya mentioned, just to get the GC perspective. So they call me and they say, I'm working with some other client. Obviously, they'll not name the client, but they say, it's a fixed price, but this client keeps nagging me with call after call after call. And when you realize what would have actually happened is that the law firm is extremely happy if those calls are for technical advice within the scope and some subject matter related knowledge or some advice on benchmarking, everything on the technical side of it. The law firm is extremely happy. The law firm has no complaints about it. But many a time we GCs want to get a psychological assurance that the bet we have taken, like it could be a litigation where we have taken a particular strategy. We want that psychological assurance that we have taken the right bet. And because it's a fixed fee, we use that power of abuse, which Navneet was mentioning. And at the end of the day, for a law firm, it's a time, so much of time is taken, their whole costing goes for a toss. So there are many instances like this where a client may kind of abuse the power of a fixed fee code. And law firms as well many times don't understand. They think it's just a different way of presentation. I mean, they think I have at the back of my mind my number of hours into this thing, so it's just a multiplication. But end of the day, I should still make the same amount of money. I mean, the client has a clear expectation that while your efforts are being paid, there is a expectation that law firms moderate and try to optimize the number of hours. Like I'll give you a simple example. There was a M&A, sorry, it's for some noise at my end. There was an M&A we were working on, and in the due diligence, there were some issues with the liability insurance policies. The law firm on my side got into so much of discussion with the law firm on the other side. And when the bill came, I said, I'd have rather bought a new insurance policy at this price. So the question is the number of hours adding any value, or is it just number of hours? So I think there is a clear expectations on law firms that don't make it just a different way of calling out a fixed fee, hourly fee assignment by just showing it as a fixed fee, but back end you expect it to be a hourly fee. Secondly, you are expected to moderate the number of hours. You have to optimize. You have to find out ways of how you can put in less number of hours on it, and try to work within the constraint. And as far as we clients are concerned, one more thing I see is many times in our urge to have fixed fee, we end up paying more. Many times clients should understand that fixed fee could be better on smaller assignments where things are quite simple. There is no complication. If you convert it into a if you convert it into a fixed fee, the law firm would make an assumption of the extended number of hours. And as a client, you could be paying much higher than what you would have paid on an hourly billing.
Yeah,
Thank you. Sir.
Yeah.
Go ahead.
I think, Veena, time has come to be a bit innovative in billing models. I mean, of course, we all appreciate. One thing which I want to tell you is we all appreciate the effort the law firms expend, because they definitely add a lot of value, no doubt about it. And I don't think it's fair on our part to make them squeeze on their effort, because that's not right, correct? But I think what is more important is, when I'm giving an assignment, I could still work with one associate and a partner, as opposed to having 3 senior associate and a partner, right? So maybe if law firms get a bit more innovative in terms of, depending on the nature of the matter, nature and criticality of the matter, saying, for this matter, we could manage with this versus this one, or at a later point in time, it gets really convoluted, we could change the structure a bit. A bit of innovation there would definitely help. And I think I go back to the same point. If you're transparent, you build the trust with your client. So no client would focus on costs if you're transparent with your client from day one.
I want to share an example now, that again, a personal incident. It was a bizarre experience for me because I was going to another city and I wanted to meet up with a particular lawyer with whom I have been engaging with. And that lawyer happened to be in the court, or he was busy or something. And I was just waiting at the reception or the meeting room. And then another lawyer walks in and says, "Oh, I work a lot with him too. I do remember your company." And, we just spoke for 15 minutes. And 1 month down the line, I actually receive an invoice for 15 minutes. He chatted with me. I didn't even know him from Adam, and I didn't even wanted to talk to him. And I received the invoice, and I think I was decent enough to go ahead and make the payment, because at 15 minutes cost wasn't much really. But I think it left a very bad taste in my experience, because I did not appreciate that kind of a gesture. It's not a rundown law firm or a mid-size or a very low level law firm where you expect perhaps, they're trying to build up on their revenue, but it was a very established, reputed law firm. So maybe it was missed by the partner, or, he thought, oh, he'll just make money on the side, or I don't know what really happened. So things like that, I think, irk the clients a lot, because we are also answerable upstairs, and it's not like it's coming from our kitty, like Harshita said. It's not our budget anyway, it's the business budget. And when they are in a fix, obviously they come running to us saying, "Oh, help us, get us out of this mess." But when we share with them the invoices, they start, "Oh, it's not me. Oh, why don't you talk to him?" I don't think it's come from this budget and things like that.
This is unreal. This is like a meme that I saw on one of those lawyer memes where they say, "I saw you on the other side of the road. I thought it was you, but I spent 10 minutes deciding whether it was you or not. Here is your bill. It wasn't you. Too bad."
So,
so
Veena, I had something similar to what Priya said, and what Sham has mentioned. I think everybody's made a lot of important points for law firms. If there are lawyers on this in this webinar who are working with firms, they will understand exactly how we think. And to Sonal's point of transparency, I think it is absolutely important. I joke a lot with my internal stakeholders, especially the business unit leaders, and I tell them that for every advice that you've asked from us and for all the work that we do, if we start charging you on an hourly basis,
Yes.
we'd be millionaires. So you're lucky that we are employed by the company. So that's why you're getting all the work done from us. But jokes apart, when we are going, when we are approaching law firms, and I've seen that to Sonal's point of transparency, I'm a huge fan of fixed price assignments. unless there are some where you do not know what is the quantum of work, because it might be a litigation matter, or it might be something else where it may be long drawn. So you cannot have a fixed price. However, in those scenarios, what we generally do is we have the price at that is capped at certain levels. So there's a general estimate that the council comes back saying that, okay, if the matter is settled off even before it gets into discovery, then we will agree to an X amount. Okay. Of course, if it's below that, and again, there has to be transparency. The law firms generally, the ones that we work with, they are extremely transparent in terms of the billings, the cost that is being billed to us. What also is very important in ensuring a cost control is outside counsel guidelines, which we've started implementing with our outside counsel. That gives a further level of transparency in terms of making sure they're not billing me for picking up the phone, and they, as you said, he tried dialing me but he could not get through, so he's going to bill like a minute of his time, and he's tried 60 times, so that'll be an entire hour of his billing rate. So I would not pay for those kind of things. So if that transparency from the in-house counsel with the external counsel is there, then it's kind of meeting in the middle and solving for any cost issues that come across for in-house counsel.
Thank you, Navroz. And I think this entire conversation on cost goes back to trust and transparency and communication at some level, right? Even if you agree to a fixed cost, if there is a contingency that happens, or if there is a development in the matter, and at least I've had the privilege of working with very reasonable clients where if there is a development, then there is no real pushback in saying, no, you agreed to X amount, and come what may, we will stick to X amount. It doesn't matter how many hours and how many days you're spending additionally. So it's about trust, transparency, communication at the right time, and that's something that I would put out there. After the whole matter is over, if you've agreed for X and the time spent is 500X, it's going to be a bit of a shock for the client to look at the bill and say, okay, this is way out of budget.
Yeah, and not to forget,
if there is bad news, please give the bad news first. Sooner the better.
But Veena, there have been instances of clients having paid that too. So when the client recognizes that, things did overspill, I think we don't hesitate really to make that.
Yeah, I fully agree. It's about communicating well, communicating on time, and billing for the right things. I hope all of these jokes are only jokes and it's not really happening in real life where you're getting billed for like calls that
my stories are not.
I want to make.
They're real life.
Oh God.
And Veena, not to forget what Sonal mentioned, right? I think trying to build efficiency, instead of 2 senior associates, you might, how do you want to build efficiency? Is there something that the firm is looking at to enhance productivity and efficiency? That's something which is important as well.
Absolutely. And I also will go back to Navroz's point here on outside counsel guidelines. I think that helps both the client and us, because some things are very clearly set out there in terms of how overstaffing is something that is not encouraged. Billing for routine research is may not be acceptable. If it's something that is like very, if it's a matter of research, it's not something that I'm expected to know, then it's a different thing. But if it's something that after so many years of experience, if I'm going to go back and look at what who's a workman under the Industrial Disputes Act, then I don't think it is something that that I should be billing you all for. So that's a conversation. Navneet had said he has a view on contingency fees. Navneet, you have anything to add here?
Yeah, Veena, I promised you I wouldn't interfere in your panel, but I couldn't resist. There's very few panaceas in this world, but there is one that applies to us. 50% of all of your time, all the general counsels on the panel, at least 50% of the time goes on cost, quality, and time. And the solution is contingency fee arrangements. Uh, I worked with a lot of big Indian companies in the United States, and all of them, the plaintiff work, if it is collection uh, or recovery of some money in some way, shape, or form, we do it on a contingency basis. Then the client is not worried about the invoice. I don't have to keep track of time, and cost, the burden of cost is on my head, the burden of quality is on my head, and the burden of time's on my head. Uh, and look at the amount of time all of you spend on monitoring fees, arguing about fees, and time and quality and all of that. And then look at a few other things, right? If the developed world, every day, everybody gets up in the developed world until the time they sleep, anything wrong that happens to them throughout their day, they don't put up with it. They call a lawyer, and the lawyer works on a contingency basis. And so piece by piece, day by day, a tiny piece at a time, the country gets better. If the lawyers are behaving in the developed world, if the doctors are behaving, if the construction people are behaving, it's because of contingency lawyering. The developed world wouldn't be a developed world but for the contingency lawyering. Then it comes to the other side of the spectrum, the poor people. Any country that doesn't allow contingency lawyering that like India doesn't, has a sign outside the country that says there is no justice for the poor in this country. How are the poor supposed to get justice if you're not going to allow lawyers to work on a contingency basis? Of the 1.3 million lawyers in India, 10,000 are doing really well, 90,000 are doing okay financially, 1.2 million are not doing fine. And if contingency lawyering was allowed, on a daily basis, the country would get better. Every screw would get tightened, one screw at a time, with the help of contingency lawyers, and the poor would get justice. So,
Point well
I,
noted, Navneet.
I
Thank you
suggest
so
that
much for
you,
that.
I suggest you, general counsels, write a letter to the state, to the Bar Council, that it's time to move on. This is 2021. For the sake of the country, for the sake of the corporations, for the sake of your time, for the sake of the poor, please allow contingency lawyering. There should not be a restraint on trade.
Thanks, Navneet. This is an important conversation to put on the table. The last aspect of that, the triangle, is time. I'm sure, and time is flying today. We're left with about less than 15 minutes. So very quickly, if you could talk to us about what really is the turnaround time, because we keep, a lot of us are told stat is 24 hours, it's 3 hours, it's 6 hours, it's a lot of firms take pride in saying it out there that we will deliver any advice within 24 hours. What is the real expectation here?
That
So
we
let
don't
me,
have to follow up. I don't like to follow up with my external counsels. That's one thing which I do not appreciate at all. I think we all are fair. If the matter is complex, you wouldn't expect 24 hours of, turnaround time. But I guess, keeping your client informed that this is a progress that we've made, this is where we are, and just be upright. That's what matters at the end of it. And not let the client make you call and ask, is it going to be 3 days? Is it going to be 4 days? So I think that communication piece is important.
Thank you.
I think the other, the other point that we generally have with, in terms of the time aspect with external counsel, as in-house counsel, if I know that I don't like to be pushed by my stakeholders, I do not expect the same from my external counsel as well. I mean, I put myself in the shoes of my counsel and I will ask the question, but how much time do I need to revert on this? So generally what we do is we will pose that question to the counsel, and I've got a lot of surprise counsel coming back saying, why are you asking us this question as to how much time do we need to get back to you? In fact, we want to know what is your TAT. I said, no, you tell us what is your TAT. You want 5 days, you want 6 days, or you want like 2 days, you tell us. And then we will make it work internally. We will make sure that we manage expectations internally. And that once you have that synergy with your external counsel, I'm sure that they will be much more happier to work with you and will give you a much better qualitative output when they know that the in-house counsel has got your back.
Absolutely. I think
That's valuable.
Yeah, I think I totally agree with Navroz. As far as timelines are concerned, reasonableness should be the governing principle. And of course, barring some emergencies and exigencies, because unless you have that trust built with the legal in-house with the law firms, they'll never have your back, especially when there is suddenly a police who lands up at your door and you have to manage that police along with your external lawyers, etc. Also, the firms must, like you said, stop overcommitting just to sort of market themselves. A particular assignment, it could be done, say, within a day's time, but just ask about when the client wants and discuss with the client as to what is the reasonable time within which you're expecting, etc., etc. Frankly speaking, most of the businesses, at least in my department, let me speak from from my own organization, the expectations is from the business team is always yesterday. They come to us today saying that this was actually due yesterday. That's a regular drama. So that time, what we do is we try and address the most critical part of the advice, right? Because when somebody comes to you with a problem, you break the problem down into multiple pieces, get to the most critical part that needs to be addressed, reach out to your your colleagues in law firms and figure an answer to that, and then work towards building. Even though the problem seems to be urgent, it mostly timelines are manageable by in-house counsels by sort of one, breaking down problems, and two is addressing the most important immediate problems will actually give the comfort to the business as well as some breather timelines for the law firm. So that's why I began by saying we've got to be reasonable as far as time is concerned, rather than proving the point that this can be done within. I mean, we are not machines and we are not dealing with machines. So, we need to have this reasonability principle really in mind.
Thank you. I think both of these points are valuable. And I think when it comes to timelines sorry, could you all put yourselves on mute, please? So when it comes to timelines, I think there is no one size fits all. It is based on the criticality and the type of question that's coming to you. And sometimes, like Harshita said, there is no need to give a super tight timeline to impress the client. The client is looking for value-based advice, for valuable advice. And what I've seen sometimes works is, even if you don't have the entire memo or the opinion ready, that's a quick call to give the client a sense of what the answer is going to be, so they can let their business teams or they can let their internal teams be kind of aligned. That goes a long way. So it again goes back to communication. So keeping the time check in mind, I'm just going to hand over the mic to each of you to talk to us about the X factor. Okay, time, quality, communication, cost, all of that is fine. In addition to all of this, what is it that you would look at in a law firm when you're engaging them? Something above and beyond. Who do we start with? Priya?
Sure. Again,
these will be your closing comments though, so I'm really sorry. Time has just flown by.
So this is again an example of an incident where fantastic law firm. I really love working with that law firm for so many years. And what happened was an opinion was solicited on a really highly sensitive employee matter, senior employee that we were trying to terminate. And what happened was the law firm did a fantastic job everything was on paper, opinion, etc., etc. When it went to Singapore, to one of the super bosses in Singapore, it was reviewed by a law firm in Singapore. And then when it went to the US, ultimately for the penultimate bosses out there, it again underwent a review by another law firm based out of US. So I think these are practical challenges that we also need to be cognizant of. And it wasn't really the law firm's fault. To me, as the in-house counsel and managing that particular matter, they satisfied my requirements and everything was perfect. But unfortunately or whatsoever, when it went up the chain, each country preferred their own law firm. So coming back to that relationship, I think that's the X factor for me. If this law firm in India, had that credibility built up, even with the penultimate bosses, as they say, I think that will help and go a long way in showcasing yourself as a global, international firm. Because I do see a little bit of a bias, and I'm going to be a little candid here. I do see a lot of biases against Indian-based law firms. Biases not perhaps intentional. It would more be about, I don't know these people, so I would rather get it checked with my own. And trust me, the Singapore-based law firm and the US-based law firm did not change one A or the. There was nothing that was changed. They reiterated and validated the opinion as is. So they found it strange that, this came to them for a review. That's a different story. So like I said, I think it is important for law firms to maybe look beyond the general counsels in India and think of this as a global client, because eventually it's all trickling down from the parent.
Sure, thank you for that. Roshan?
Sure. So I think the X factors, again, just go back to everyone just mentioned about transparency, right? So be transparent, and also you're the extended part. So while the in-house counsel is front-ending the issue, I think it's an extended part of the team. So I'd expect a law firm to be partnering with me, collaborating with me as an extended team. So I think that's something which I would like to take off, from this session.
Thank you, Roshan. Who wants to go next, Sonal?
Yeah, I would just say be an insider, don't be an external consultant.
Sounds good. That's very punchy, and that's going to stay in a lot of our minds after this session. Thank you, Sonal. Shyam?
Yeah, in addition to what has already been said, I think one factor be that whenever we engage a law firm on a particular assignment, there is a journey and there's a destination. I mean, we want things to go in a particular way and achieve a particular destination. So it's extremely important that the law firm can understand what the client wants. Just to give an example, sometimes on a litigation matter, we not only want to win the litigation, we want to frustrate the other side in a particular way. And sometimes we may want to give what the other side wants, but after a particular amount of resistance built from our side. So it's extremely important that the law firm understands what is it that the client expects and then deliver accordingly. That will go a long way. And that is, as per me, an additional X factor in addition to what other panelists already mentioned.
Thank you, Shyam. Navroz?
So most of you must have already seen the movie The Godfather, and the role that Robert Duvall played as Tom Hagen as the consigliere. So, who's a trusted advisor. So what I look at a law firm, who I'm taking on board or I'm empaneling is going to be, they should be my consigliere and basically saying that, okay, they are my trusted advisor and they got my back for, in any matters that I go to them for.
Thank you, Navroz. Harshita?
I think that X factor would be the connect. At the end of the day, it's the connect that I built with the law firm, the law firms that we work. Unless we are dealing with humans, and I keep emphasizing this because At the end of the day, it's all built on relationships, rapport building, confidence, trust, etc., etc. It's that connect that's very important. I mean, there could be very competent law firms who can actually provide a great service, quality service, that the quality that we were all talking about. But unless you sort of you get a person who totally understands your point of view, understands the problem, and understands where you're coming from, including the goals, etc., etc. I think that's one thing that's really important. I mean, that's the X factor that I certainly look for. In addition to that, if you may allow me, I mean, as X factors, people could also really think of 3 things, in my opinion. One is apply reasonability check on the invoices that you send. Just before an invoice is sent, quickly take a look, see whether the deliverable really commensurates with the effort and with the rate that you have agreed, so that there is, that do not ever give the sense of that I've overbilled to the client. That's very important. 2 is pragmatic. I mean, be pragmatic. We are not working in any textbook framework. We are actually, you're helping us run our businesses very effectively. So therefore, be pragmatic. And 3 is reflect on your own culture, right? It's extremely important. Think about, things like your ethics, your diversity, your, sustainability concept. I think these are really ignored in India, and these must be taken up much. All the stereotyping that we have about how if you're in a law firm, you got to put in 14 hours a day, work on every weekends, etc. We got to stop all of that, and I think there's a huge responsibility of in-house companies in making this happen. That's really important. Basically establish boundaries between working and not working. It's very important to take care of mental health of your lawyers in the law firm setup, etc., etc. So all of these things must be also considered. And if there is a firm like that, then obviously you would relate, and because all of our corporates now have moved towards D&I, have moved towards inclusion, sustainability, etc., etc. We would like to see our service partners also sort of extend these kind of imbibe these kind of principles to go a step ahead in helping us achieve our goals.
Very important, very, very, very important, because and it works both ways, right? We often find ourselves sometimes talking to a client who may not be very sensitive in terms of concepts of diversity and inclusion. Similarly, I've got similar feedback from clients where there are top corporate lawyers who end up making sometimes extremely inappropriate, possibly racist, globally racist, sexist comments. So when and like all of you have said, it's about partnering and collaborating, and we can only do that if we are aligned in terms of visions, goals, principles, ethics. So all of that. So thank you so much. We are at 12:35. If any of you have, I have been told that from a tech perspective, we can spill over by a couple of minutes. So if you have anything to add, let me know. Otherwise, we will wrap up. Good to wrap? Excellent. Thank you so much. Super grateful for your time, and I hope all the attendees found this session useful. Again, thank you, Navneet. Thank you, Madhura, for putting this together and for providing this platform for us.
Thank you, Veena, for
Thank you.
Absolutely
you.
wonderful.
Thank you.
Thanks. Bye.
Thank
Bye,
you, everyone.
everyone.
Thanks to all the panelists.
Bye.
Bye.
Thank you, everyone. Bye-bye.